Hello everyone, welcome to Get.Set.Law. In this session of Law Wednesday, we will be discussing the Uniform Civil Code and the public notice of 22nd Law Commission. So, Uniform Civil Code has been given under the Indian Constitution, Article 44. Now, the 22nd Law Commission has released a public notice in which they have asked for the opinion of the public whether they want to implement the Uniform Civil Code or not. So as you can see in the screen that on 14th June, the Law Commission of India has released this notice which says that public notice will be taken into the consideration. So you can see here that either you can go through the link which has been given in this particular tab called click here, or you can email to the member secretary of the Law Commission. Now, it is worth noting that back in 2018, the 21st Law Commission said that right now there is no need to implement the Uniform Civil Code. But again, after 5 years, it is worth questioning that whether we have a need for Uniform Civil Code or not. And that is why the public notice has been released by the Law Commission of India. So in this session, we will see what Uniform Civil Code is, what is its relevant, and where are we standing right now. So please join me. Now, as I already told that 22nd Law Commission of India has decided to take the opinion of the public, and why they are taking the opinion of the public, because Uniform Civil Code will try to merge all the religious practices. So for example, when we talk about marriage, inheritance, succession, so we have different kinds of personal laws which is based upon the different customs, which is based upon the religious practices. So that is why it is very important to take the opinion of the public in this regard. This commission has been headed by the former Karnataka High Court Chief Justice Ritu Raj Avasthi, and initially, as I mentioned, that in 2018, 21st Law Commission of India has issued a consultation paper. Now, what is Uniform Civil Code? What is this special thing about it? Uniform Civil Code has been laid down in Article 44, which says that a state should put an endeavor to uniform the practices across the country. So it is very important, but it is another thing which is to be noted that the Article 44 has been kept under directive principles of state policy. One thing I would like to tell you that there is a minor difference between the directive principles of state policy and fundamental rights in the Indian Constitution. Whereas fundamental right is enforceable in the court of law by the Article 32 or 226, which gives the power to the Supreme Court and High Court respectively under the writ jurisdiction, but directive principles of state policy are non-enforceable. Now, what do we mean by non-enforceable? It means that even though certain societies think that Uniform Civil Code shall be implemented and they really want to get it implemented, and even it is causing a harm by non-implementation, still they cannot take a court case in this regard. Therefore, it has been kept under directive principles of state policy. It is worth noting that during the formation of our Indian Constitution, so as soon as we got the independence in 1947, our Constitution started making, and very interestingly, various drafters of our Indian Constitution has deliberated upon this issue whether we really want a Uniform Civil Code or not. This question was very much relevant because at that point of time there was a huge tussle between India and Pakistan, which is directly correlating with the Hindu and Muslim. So since the Uniform Civil Code was a matter of personal law and we did have different codes for Hindu and Muslim practices, so it was a very huge question whether such diverse background can be clubbed into one, and can Uniform Civil Code be into the picture. So this was a discussion which was happening in the Constituent Assembly at that point of time, and after many discussions and deliberations they thought that we will put into the directive principle, so that later on if any government thinks that it is the right time to implement the Uniform Civil Code, they can do so. And on the other hand, no one can claim it as a matter of a right. So this is a very quick gist of what has happened during the Constitution. Now we will see what has happened prior to the Constitution. So it has started back in 1835, where it has been stressed by the British government that there is a need for the uniformity in the codification, because even though prior to the making of Constitution we had different religious communities existing together in the territory of India. So British government has witnessed this issue that there are multiple personal laws and it is causing a trouble to the British government, and that is why they stressed in a report which was released in 1835. They said that there has to be a unification of these different laws, and specifically that report mentioned the unification of Muslims and Hindu law. Later on, the Lex Loci report of 1840 again re-stressed, which is just after the 5 years, that we need to have a unification in the terms of crimes, evidence, contract, and moreover we definitely need a unification in the terms of personal laws of Hindus and Muslims. Thereafter, after 20 years in 1859, the Queen's proclamation come into the picture, and they said that because there was a different issues with the different religion, the Queen's proclamation ensured that there will be absolutely no interference in the religious matter, and the unification will definitely leads toward a particular issue, that is giving the equal rights to the gender, that is neutralizing the different practices which has nothing to do with the religion per se. And that's how different attempts were made, and finally we got the criminal laws unified, which was in 1860. The Indian Penal Code was brought, and whenever any crime will take place, irrespective of the religion, the IPC will be taken into consideration. So this was a very big step back in 1860, when the first step towards the unification has been taken. And as I mentioned that this was the journey which the British government has took over, and later on the Indian government has also faced the trouble. So after getting independence in 1947, our constitution was brought into the picture, and thereafter we got in 1956 Hindu Marriage Act, and later on second step was taken in order to unify the criminal laws, that was in 1973 Criminal Procedure Code. So this is how we have swiftly moved. And as I mentioned that during the making, the B.R. Ambedkar, Jawaharlal Nehru, B.N. Rao and other notable contributors of our constitution had a wide discussion, but they could not come into a proper conclusion. And thereafter, Indian judiciary come into the picture. 1985, we had a very prominent case, which is the case of Shah Bano Begum versus Union of India. In this case, a 73-year-old woman called Shah Bano got divorced, and it is a prevalent practice in the Muslim law which is called as a triple talaq, in which husband just say divorce, divorce, divorce. Merely by saying divorce 3 times, divorce used to get enforced, which was a grave injustice for the women at that point of time. And similarly, the Shah Bano Begum took this to the Supreme Court that it is a highly injustice because we are not getting the proper rights. Again, Supreme Court took the matter into the consideration, and back in 1985, Supreme Court gave the decision under the All India Criminal Code section 125, which takes into the matter of maintenance, and they said that irrespective of the religion, maintenance shall be given to the women, because before religion we are humans. So this was the notations of the court, and because of which court sidelined the personal law and gave the unified right to the Shah Bano Begum. Court also said that it is a high time, that it's been 25 years that we have got the independence, we need to bring a unified laws. Thereafter, just in 10 years, another case happened of the Sarla Mudgal versus Union of India. In this case, again there was a question whether a Hindu husband married under the Hindu Marriage Act, as I just mentioned in the previous slides that we got this act in 1956, can solemnize a second marriage by embracing Islam, because it is another prevalent practice in the Muslim religion that man can have up to 4 wives. So certain people were taking this advantage that they were converting their religion from Christian to becoming Muslim, from Hindu to becoming Muslim, and already they were married and they were solemnizing another marriage. So this was a question before the court of law, whether if I switch to the Muslim religion, so can I get to have 4 wives under their personal laws? So this matter was dealt by the Supreme Court, and they said that a Hindu who is married under the Hindu Marriage Act needs to take a divorce first under the Hindu Marriage Act, and then only the second marriage will be solemnized. So this decision was taken because in order to protect the rights of women, because the first marriage is also important and the rights of wives needs to be considered. So if anyone changes their religion for the sake of marrying for the second or the third time, court said that it will be an offense under section 494 of Indian Penal Code, which is the offense of bigamy. Bigamy is marrying for the second time when the first wife is present. Now we will see that we have saw the very gist of the Uniform Civil Code, that how Uniform Civil Code has come into the picture and why 22nd Law Commission has brought this to the public notice. Now we will try to consider what are the different pros and cons, because it is the responsibility of us that all of us has got the opportunity to vote for the Uniform Civil Code, to express our opinion, and we can only express our opinions if we know about the matter properly. So as we have gone through the history, now we will also calculate what are the different pros and cons of the Uniform Civil Code. So the few pros of the Uniform Civil Code are that it will provide to the vulnerable sections. Yes, it is very right, and this was envisaged by the B.R. Ambedkar also, that women and children are the vulnerable section of the society, and certain minorities which are coming under the religious heads, they are also the vulnerable section. So having a uniform law in the matter of divorce, adoption, maintenance, succession, inheritance, this will definitely give right to all of these religious minorities, or either to the women or children. This will also simplify the complex law. So as I mentioned that there are different laws of marriage for Hindus, Muslim, Parsi, Christians. So all of this creates a issue. So for example, if I want to marry a Muslim girl being a Christian, or being a Muslim I want to marry a Hindu person, so all of it has a very complicated legal structure. So all of this will be resolved, and it will be very easy for judiciary to inculcate the few fundamental rights of an individual based upon a uniform law. And third, it is very important that it will improvise the gender equality in our country. So gender inequality is one of the prime reason which we are facing right now, and this will be solved by having a uniform laws. And the last reason is again very important, which has been given in the preamble also, that we have a character of secular country. So when we call ourselves a secular country, we shall neutralize the religion. So it has been said that being a secular tag, we give freedom to all the religions. But before that, it is very important that we need to unify the fundamental right. We need to unify the rights of an individual, of women and children specifically. So discrimination on the basis of the religious practices should not lead to the violation of fundamental rights, or should not lead to the violation of basic human rights. So these are the different pros, these are the different pros, and now we'll see the different cons. Now the cons are that one of the prominent reason behind the lagging of implementation of UCC is the diverse customary practices, because custom is a source of law, and that is how different laws are made on the basis of personal practices. The constitution itself gives power to the local customs of Nagaland, Meghalaya and Mizoram. So it is a very contradicting provision that one side constitution itself give a shelter to the different communities, and one side we are trying to implement the uniform civil code. And the another issue is the caste politics. And the major political issue is that a large sect of society thinks that it is nothing but a political gimmick, because in order to bring a one religion, or in order to bring the uniformity into the law, many people thinks that they will be under a trap of majoritarianism. So this is one of the prominent issue, that is lack of awareness towards the uniform civil code. So it is very important that a proper steps should be taken in order to aware the public that what the uniform civil code be. Lastly, Article 25 of our Indian Constitution gives right of religion, right to practice religion, right to have a customary religious practices. So this right is again contradicting with the Uniform Civil Code, that a person can object that I have a right to practice my religion and my religion says so. For example, if we cut out the provision of marrying four men, a men having a four wives, so it will be a problem for a Muslim community, because they can claim that we have a right to practice religion and it is permissible in their religion. So technically it is something which is not allowing them to practice their religion. So this right is guaranteed by the Article 26, and as I in the very first slide mentioned, that Article 25 has the nature of fundamental right, whereas Uniform Civil Code is a directive principle. So definitely the fundamental right will be given prevalence over the Uniform Civil Code. So these are the different pros and cons of the Uniform Civil Code. But again, an important question pops up, that can we bring a balance in this between of pros and cons? So we need to see what is the status of Uniform Code right now. In certain areas, thankfully, we have come into a conclusion where we have brought the similar instances. For example, Indian Contract Act 1872, Civil Procedure Code 1909, Transfer of Property Act 1882, Evidence Act 1872. So these are the certain acts under different civil and criminal matters, property matters, where we have brought the uniformity, and the exchange of property, selling of property, it is all been unified irrespective of your religion. So this is the one of the great steps which our country has already achieved. Now it is important to note that Goa is the only state in the India which is following the Uniform Civil Code. So it's way ahead for another states to join, and it's a high time that we should also implement Uniform Civil Code in order to upskill the equality between a gender, which is enshrined under Article 14 of the Constitution. Now, as we discuss the pros and cons, it is not impossible that we can bring a balance in the country. So it is a very important task for government and society both, that they should build a trust, and more importantly we should work with the various social reformers rather than preferring the religious conservatives, because the tussle between the religion and the law will never end, because it's both are on a different shores. So that is why it is very important that how we can bring a balanced reform in the country, and the government will play a majority role in this, that they should keep aside the vote bank politics, keep aside the different political gimmicks, and should definitely try to gain the trust of the public in order to proclaim that the Uniform Civil Code is a right code which has a balance of the different kinds of religion. And as soon as the public trust will be gained, it will be very easy to implement the Uniform Civil Code. So that is how we can see that how Uniform Civil Code can be prospered in our country. We have seen the different perspectives, different background, and the cases of the Supreme Court. So I hope you have understood the concept of Uniform Civil Code, and see you in the next week. Thank you.